Welcome to the Ask Junior Daily Judgment podcast. I'm Priya Sharma, and joining me today is Arjun Gupta.
Hello, everyone. We're excited to dive into today's important judgments. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Now, let's get started with today's case, Ayub Khan versus the State of Rajasthan, decided by the Supreme Court of India.
This case is fascinating because it delves into the delicate balance between judicial independence and administrative control. Let's break down the facts.
The case revolves around Ayub Khan, a district and sessions judge in Rajasthan, who was embroiled in a dispute with the High Court. It all started when Ayub Khan rejected a bail application for an accused facing serious charges, including attempted murder and illegal possession of arms.
The High Court had previously issued directions in a case called Jugal Kishore versus State of Rajasthan, requiring trial courts to include detailed antecedents or past criminal records of accused persons in a specific format while deciding bail applications.
Right? So Ayub Khan, while rejecting the bail application, didn't adhere to this prescribed format. He simply mentioned that there were 10 criminal cases against the accused without providing the specific details.
This triggered a chain of events. The High Court viewed the non-compliance as judicial indiscipline and even potential contempt of court. They issued a series of orders demanding explanations and reports from Ayub Khan.
The Supreme Court stepped in, hearing Ayub Khan's appeal against the High Court's actions. This brought up several crucial legal questions.
Absolutely. The central issue was whether the High Court could impose a specific format for bail orders through administrative directions. This raises the question of the boundaries of judicial authority and the degree of freedom trial courts should have in their judgments.
Think about it this way. Imagine you're building a house. The Supreme Court sets the foundation and walls, the broad principles of bail. The High Court then suggests a specific design for a window, the format for recording antecedents. But can the High Court force the builder to use that specific window design, even if it doesn't affect the structural integrity of the house?
That's a great analogy, Priya. The Supreme Court, like the foundation of the house, ensures fairness and due process in bail applications, but it doesn't have to dictate the specific format of the bail order, especially when that format might not be relevant in every case.
Exactly. The Supreme Court emphasized that the presence of antecedents is just one of several considerations when granting bail. In certain circumstances, like default bail or cases involving long incarceration, antecedents might be irrelevant.
The court also pointed out that a mandatory format could unnecessarily delay bail proceedings, as judges might need to gather detailed information about the accused's past, leading to adjournments.
The second legal question was whether noncompliance with the High Court's format, which was merely suggested, constituted judicial indiscipline or contempt of court.
The Supreme Court clarified that noncompliance with a merely suggestive format couldn't be considered either. It emphasized that the High Court's approach of calling for explanations and reports from a judicial officer through judicial orders was problematic.
Think of it like this. Imagine you're a teacher and you give students guidelines for a project, but you don't make them mandatory. If a student doesn't follow those guidelines, can you directly punish them? No. You might have to address it in a different way, perhaps through a discussion or feedback.
The Supreme Court argued that such matters should be dealt with on the administrative side, allowing the judicial officer a chance to defend themselves.
The third legal issue concerned the appropriateness of passing adverse remarks and strictures against a judicial officer in judicial orders without giving them a chance to defend themselves.
The Supreme Court cited a previous case, Sonu Agnihotri, emphasizing that while higher courts can criticize erroneous orders and rectify mistakes, personal criticism of judicial officers should be avoided.
Judges, like everyone else, are susceptible to stress and errors. The Supreme Court acknowledged that judges operate under immense pressure with high workloads and inadequate judge-to-population ratios. The court reasoned that making personal remarks in judgments could unfairly prejudice a judicial officer's career prospects.
Imagine you're a doctor and you make a small mistake while treating a patient. Should you be publicly criticized and potentially lose your job? It's essential to differentiate between genuine mistakes and deliberate wrongdoing, especially in professions like law and medicine.
Based on these arguments, the Supreme Court delivered its judgment. It expunged all adverse remarks and observations against Ayub Khan in the High Court's orders, setting aside the findings of disobedience and indiscipline. It also clarified that the format requirements in the Jugal Kishore case were merely suggestive, and non-compliance couldn't be treated as indiscipline or contempt.
This judgment highlights the importance of striking a balance between maintaining judicial standards and ensuring fair treatment of judicial officers. The court's decision reaffirms the principle of judicial independence and emphasizes the need for appropriate administrative channels to address issues related to judicial conduct.
And that wraps up our analysis of today's judgments. We hope you found our discussion informative and engaging.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions.
Absolutely. And don't forget to tune in tomorrow for another exciting episode. Until then, this is Priya Sharma.
And Arjun Gupta, signing off. Thanks for listening to the Ask Junior Daily Judgment podcast.